morning. Be seated, please. Welcome again to an oral argument session of the 5th District Court of Appeal. The panel has changed. You've already met Judge Wallace, and Judge Edwards is on my right. I'm Judge Orfinger, and we're here to hear the last two cases. Well, Judge Edwards is not here the last two cases. He's here for one case, and then Chief Judge Cohen will be joining us for the last case. So let me get my glasses on so I can read the docket. We have Memorial Hospital versus EPPES. And the clock is set. If appellant would like to reserve more than 5 minutes or less, let me know and I'll set the clock.
Your Honor, 4 minutes would probably be sufficient if I may.
Okay. When it flashes orange, you'll be into your rebuttal time. You may proceed whenever you're ready.
May it please the Court, my name is Travis Erickson. I'm here on behalf of Florida Hospital FLAGLER, as well as Dr. Dennis Alter and Florida Hospital Healthcare Partners. Your Honors, the petition for writ of certiorari arrives to you today to ask this Court to answer one question, and that is whether the law in a pre-suit of a medical malpractice action prefers that plaintiffs do nothing to try and comply with the Medical Malpractice Act as opposed to something. Because that is what Judge DuPont ordered, is that in the context of an amended version of a complaint, it was better that the plaintiffs had done nothing to attempt to comply with pre-suit rather than anything to comply with pre-suit. And let me explain what I mean by that.
Well, you concede that at least on the initial claim they pre-suited that and there's no issue there.
And that's where I was going to go to, Your Honor.
Now we've got the new claim, we'll call it the pharmacist claim. And your contention is that because that wasn't part of the initial pre-suit that they have to post-suit. Or they have to do so, they have to pre-suit it before they can assert that claim, assuming that they're able to do so.
And what's fascinating about this to me, Your Honors, is that in the lower court, and the respondents would agree today, first of all, that there was never a notice of intent that alleged any negligence on the part of the hospital as an institution or its employed pharmacists.
Let me ask two questions.
Yes, Your Honor.
Number one, let's start off with this. What part of the statute would require more than that they pre-suit to demonstrate they have a valid claim?
More than one part. 766.203 sub 1 talks about having to investigate all claims of medical negligence, and what's important is that the statute's changed in 2003. And what was important about the change in those statutes? It went from a very permissive, you need only one affidavit in order to open the courthouse doors, to you need an affidavit from an expert who would be qualified to testify at trial as to each standard of care that you intend to bring into the lawsuit. A hospital wears many hats and can be alleged to be vicariously responsible in many different ways. So back to your point, Your Honor, we had a September of 2015 notice of intent that alleged one thing, that was nursing negligence, supported by the affidavit of a nurse. What we have 2 years later, in August of 2017, is the order from Judge DuPont that said in this amended version of the complaint, even though there's been no pre-suit compliance, even though there's been no investigation, even though there's been no affidavit and no notice, you are allowed to amend the complaint to take it anywhere that you would like. Think
so
about
is the basis upon which you distinguish the Columbia versus Brown case, the change in the statute?
That is one of those, Your Honor, but I think the cases that the respondents rely on out of the 5th DCA probably would be the Davis case and then the Jackson case. The Davis case, Your Honor, actually doesn't deal with the contention that the pre-suit affiant was unqualified. The Jackson case, in much the same respect, there was no contention there that the pre-suit process was not satisfied under those prior statutes. What, again, is fascinating to this about me, Judge, is that below, and again today, the respondents will agree that if these claims had been brought in an initial version of a complaint, that Judge DuPont would have been required to have dismissed them. And if for any reason he denied the motion to dismiss, and we were here before you today on the initial version of the complaint, that your honors would be compelled by the law and your own law to have remanded for dismissal.
Davis versus ORMC, though, weren't they allowed to bring in not just a different theory, but also a different injury by amending the complaint?
Well, it wasn't actually an amendment to the complaint. It was an amendment to the theories or the opinions of the expert.
Right, and the hospital moved to strike the testimony or limit the testimony or dismiss the case. But I mean, ultimately, that's where it was headed. It was, if they were going to make that claim, they probably were going to have to amend the complaint.
There is no argument under that case, and again, it's from 1995, that the pre-suit affiant would have been unqualified to have made those claims, though, and that's what distinguishes it from this case today. There is zero effort at compliance in the case before you today. In Davis, there was some compliance. So arguably, under Davis, the plaintiffs in those older versions of the statutes did what they had to do. But again,
had the statute of limitation expired by the time of the third amended complaint being filed?
I don't know that to be true, Your Honor. But what's interesting about that, Judge, I'm glad that you brought that up, because it's one of the ultimate prejudices to a hospital, which again can wear so many different hats in a lawsuit under a vicarious liability theory. And just to demonstrate for you, those two notebooks that I set on the table are the medical records from Mr. Epps' admission to the hospital, almost 1,000 pages. They involve cardiologists, emergency medicine physicians, orthopedic surgeons, nurses, neurologists, physical therapists, occupational therapists, and many more. Tens of thousands of medical record entries, Judge. And to your point about the statute of limitations, if the argument is that the plaintiff might run past a statute of limitations, but can amend the complaint at any time to say anything that the hospital is going to be responsible, think about the prejudice to the hospital. The hospital can't implead and bring those other parties in to be a part of the lawsuit, even though it could arguably be held responsible for them, Your Honor. That's part of the prejudice in the plaintiffs not complying with their pre-suit obligations in order to amend the complaint. So again, to bring this full circle back to what is so odd about the order that Judge DuPont entered, is that, again, if we had been here on an initial version of the complaint, there's no question that this court would have reversed, would have remanded and, granted the petition and remanded back to the trial court for compliance with the pre-suit process. It didn't happen here because we're on an amended complaint and the plaintiffs did nothing. Had they even attempted to do something, I could have argued pre-suit non-compliance. Because they did nothing, the lawsuit then can become anything. And I think that is contrary to the intent of the statute, the intent of the Medical Malpractice Act. What do I mean?
The intent, the plain language of it, is there somewhere in there that it says once you've got an action going, you have to then post-suit, do a post-suit, pre-suit?
That is 766-203 sub 1 that talks about having to pre-suit all of the claims. Sub 766-203 sub 2 then says you have to provide notice. The notice has to be corroborated by an affidavit from a qualified affiant. What changed in 2003, Your Honors, is that prior to that, those old cases, it essentially said that you have to have somebody with a college degree who has knowledge of the issues.
Versus a specialist or somebody with a hospital knowledge.
Precisely. In fact, that's the Blom case out of this court, where they allowed a nurse to testify on, to offer an affidavit on causation, even though the court acknowledged in Blom, this court, that that same nurse may not be allowed to do so in a trial context. When you fast forward to 2003 and those statutes that took effect in September of 2003, you see that not only do you have to have an affidavit, but it cross-references 766.102, and that's where you have all the requirements for an expert. You have to have, and this is the heart of the argument, you now have to have, in a pre-suit context, confirmation that each standard of care has been corroborated. So if you want to sue a hospital for the negligence of a neurologist or the negligence of an OBGYN or the negligence of an emergency room physician, you have to have somebody in that same specialty to corroborate it. And if you don't, then the pre-suit requirements haven't been satisfied.
Just so it's clear, there was a second amendment to the complaint that added Dr. Alter, correct?
I believe it was a First Amendment to the complaint. There was well, let me back up. There was a second notice of intent that alleged that Dr. Alter was negligent.
So Dr. Alter was properly pre-suited in your opinion?
He was. He was properly pre-suited. There was a second notice of intent that included an affidavit from an orthopedic surgeon. There was...
Dr. Alter was not under the umbrella of Florida Hospital Flagler, correct?
He is part of Florida Hospital Healthcare Partners, which is in association, loose association with Florida Hospital Flagler.
An independent practice group that practices within Florida Hospital Flagler.
It is regarded as an independent contractor, Your Honor, yes.
And because they're not an umbrella under Florida Hospital Flagler, that was proper to pre-suit individually Dr. Alter, correct?
It was, and then there was no allegation of vicarious liability against the hospital for Dr. Alter, at least yet. But had there been, Your Honor, it would have still been my argument that if they did not provide that notice to the hospital, then they were obligated to do so in order to satisfy the pre-suit requirements.
Would they be required, let's just use Dr. Alter, and I'm going to give you a hypothetical. So they do a pre-suit, and they say that the doctor was negligent because he cut the wrong leg off. And they pre-suit that, everybody's good with that. And then they do some discovery, and they find some other allegation. You know, he was negligent because he didn't provide proper follow-up care and the patient had a stroke or something. Would it be your contention if they wanted to amend the complaint to add those additional allegations of negligence in post-surgery follow-up that they would have to pre-suit it again because...
No, absolutely not. My contention is that the argument is based on the standard of care. If you want to amend now to, we have nursing negligence and we have Dr. Alter's negligence alleged in the complaint, and both were preceded by a pre-suit process with an affidavit from a corroborating affiant. If you now want to amend the complaint to allege that the nurses were negligent in some way that they have not been alleged to have been negligent before, then I think the law, in most circumstances, is going to allow that amendment to occur unless, of course, we're 10 days away from trial, it hasn't been subject to discovery, something of that nature.
So if they had alleged initially in their pre-suit that the nurses were negligent because they didn't check on him often enough and didn't notice that he was going into respiratory arrest or something, and then they want to add an additional complaint they were negligent because they dropped him on the floor, assuming that that's medical negligence.
Right.
I don't know if it is or it isn't, but...
Some cases it is, in some cases it's not.
That's right. If that is medical negligence, would it be your contention that they would have to separately pre-suit that because that's a different standard of care, or is it the same standard of care?
No, I believe the nursing negligence to be the same standard of care, just like orthopedic standard of care is one standard of care. A neurologist's standard of care is one standard of care. You simply have to have somebody from that same specialty to corroborate that there has been negligence on the individuals on that.
What does a
context.
medical negligence claim mean? Is that the case? Is that a theory? I mean, the statute uses the term medical negligence claim.
I think it has.
Is that a theory? Is that a cause of action? Is that a lawsuit? What exactly is that in terms of a medical malpractice case with multiple defendants and multiple theories?
And I think it has to be read in par materia with the other statutes, those other subsections which we talked about. Well, and I guess we could say this about many different statutes. We wish they could be written in a little bit more clear fashion. But in conjunction with the obligation under subpart 2 of 766203 to serve a notice and then to corroborate that notice with an affidavit from somebody who's qualified to be an expert affiant, that takes you, of course, to 202 sub 6, which takes you to 102 and sub 5 through 9. Sub 5 talks about those who are specialists, like an orthopedic surgeon, Sub 7 talks about the obligation on the part of a hospital as an administrative institution. And Sub 6 talks about those folks who are support and medical staff, which arguably would be the pharmacists in this case, because they are employed pharmacists. So read in para materia, it means, in my reading of the statutes, Judge, that when you bring a lawsuit, each standard of care has to have been supported by that pre-suit process.
And in the original lawsuit, the claim was the nurses failed to properly administer the narcotic medication, correct? That was part of the allegation.
That was part of the allegation, that nurses...
And the discovery then developed where they got the narcotic medication from, which was the pharmacy.
You know, Judge, I think it's a bit of a distraction in the respondent's brief to argue that somehow the discovery made a difference here because medications always come from the pharmacy. But even if that's true, and I'm not conceding that, but just for the sake of argument, let's say that some part of their discovery...
Well, you as the hospital would be hiding behind a defense or using a defense if, you know, some loved one who didn't feel like their loved one was being treated properly was bringing narcotic medication into the hospital and giving it to that loved one. If you, as the hospital, knew that, that would certainly be a defense, correct?
Well, we don't believe that the pharmacy did anything wrong, but there's never been corroboration.
I'm saying hypothetically. You say everybody knows that the medication comes from the pharmacy as part of the hospital. But if that factual twist was playing out in this case, you would be pleading that as a defense, correct?
I don't know that we've gotten that far in terms of how we were going to present at trial the arguments. I candidly don't. But even if the discovery ultimately made a difference in how they believe they needed to frame their case, again, under Blom, out of this court, their remedy is simply abatement of the civil action in order to allow the plaintiffs to comply with the pre-suit process.
When I look at the statute, I'm looking at 766-203. It says, you know, prior to initiating the intent to sue, the claimant has to conduct the investigation to ascertain A, any named defendant in the litigation was negligent in the care and treatment, and B, such negligence resulted in injury to the plaintiff. And you got to have the affidavit from the qualified expert. And, I mean, wouldn't we have to expand that to say, I mean, if that you've got to bring an expert on every separate theory, every separate, you know, if you've got pharmacy, let's just use the hospital. You've got pharmacy negligence, you've got operating room nurse negligence, you've got floor nurse negligence. So you're going to have to bring in different experts on all of these different fields.
Your Honor, if I may, let me answer your question with a question, which is, why does that change when it is the initial complaint versus an amended version of the complaint?
See, I get to ask the question.
And I understand. It was rhetorical.
That's the beauty of this opera.
It was more rhetorical than anything, but the law shouldn't change just because time has gone by. It could be as simple as a matter of 20 days, Your Honor. A complaint could be answered, an amended complaint could be then filed with the court, and then it becomes anything. And that shouldn't be the law, that a hospital is subject to responsibility for anything that a plaintiff wants it to be, even though there's not been pre-suit compliance.
You're down to 2 minutes and change if you want to hold on to
I
it.
will hold on. Thank you, Your Honor.
Good morning.
Good morning. May it please the court, my name's Kevin Moore, and I'm here on behalf of the respondents, Mr. and Mrs. Epps.
Do you agree or disagree that if you had brought the ultimate complaint that's pending now, pre-suit, that you would have had to have different expert affidavits to support the claim of nursing negligence versus pharmacy negligence?
Your Honor, legally, I don't agree with that. Practically, if I would have known of these issues at the beginning of the lawsuit, just as a matter of protecting my client and myself, I probably would have done that. but I don't think after having researched this issue and briefed it that would have been necessary. No, sir. I think that what the statutes require is that, to me, the pre-suit process kind of serves as a gatekeeping function, and it allows for, it's there to ensure that frivolous lawsuits aren't being filed against hospitals, doctors, et cetera. And in order to do that, it requires that...
Does it require is it designed to prevent frivolous lawsuits or frivolous claims? Because in the intent of the legislature, when you look at that provision, it talks about it's designed to prevent bringing, frivolous claims or defenses. So, if you got 3 claims, 2 of which are well-founded and 1 of which has no evidentiary basis, is it designed to prevent you wasting a lot of time on that one that doesn't have any evidentiary basis if you can't come up with an expert? I mean, it says the pre-suit, I'm looking at 766-201.
Okay.
2A, pre-suit shall include verifiable requirements that a reasonable investigation precede both malpractice claims and defenses in order to eliminate frivolous claims and defenses. So it doesn't say frivolous actions, but it talks about claims and defenses. So my concern when I look at that statute is that they seem to be focused more on individual claims and individual defenses, as opposed to saying, look, if you can bring one legitimate or at least one claim that passes the pre-suit requirement, you can't throw in 10 that are questionable.
Your Honor, I understand your concern, and I think that as I read other portions of the Medical Malpractice Act, specifically 766.106(2A), it discusses the pre-suit notice, and it says, after completion of pre-suit investigation, pursuant to 766.203, and prior to filing a complaint for medical negligence. So in this area of the statute, it just refers to the complaint itself. Prior to filing the complaint, you shall notify each prospective defendant by certified mail of your intent to initiate litigation, which we've done here. 766.203, prior to issuing notification of intent to initiate medical negligence litigation, which Your Honor addressed earlier, we have to conduct a reasonable investigation, which we did. And practically, Your Honor, this court in Davis made an excellent point when it said, and this is a quote that that really resounds, I think, in this case. It's virtually impossible for a plaintiff to identify every instance of medical negligence at the pre-suit stage. The petitioner pointed out the wealth of medical records we have in this case. We had all those pre-suit to review and try to determine what our best avenues of recovery were for the client. And after reviewing them, what we determined was that the nurses were negligent in their care and treatment of providing medications, not monitoring enough for the desaturation she was experiencing. And then, after months and almost, a year and a half of discovery, we finally received the pharmacist's power plans, only after compelling them from the defense. We'd asked for them in discovery before, they refused to turn them over. After we received them, after the court compelled it, we then found pharmaceutical negligence, to which we moved to amend our complaint to add. So we had no access to this information in the pre-suit stage. There's no way for us to know any of this. So, I think practically an example that I tried to create for the court to help us understand what the implications of a decision in favor of a petitioner would mean is a simple one. So a patient comes into the hospital complaining of indigestion. He's diagnosed with complaining of chest pain, He's diagnosed with indigestion and sent home, and 24 hours later, he dies of a myocardial infarction. We gather the patient's medical records. That's all we have access to at this point. We see that the nurse failed to take a proper history, which would have allowed for a proper diagnosis of myocardial infarction. We do our notice of intent, we do our affidavit, we do the whole pre-suit process, everything's adequate, we file suit. Months or a year later, we're deposing a radiology technician. We learned that during a chest x-ray, he actually took an adequate history from the patient, but failed to pass that on to the doctors or the nurses or anyone else. So at this point, we seek to amend our complaint to add these new allegations of negligence. Well, according to the petitioner, we would have to then file another notice of intent, another affidavit, go through another 90-day pre-suit process, delaying, causing extra time and expense. Things that the pre-suit process was meant to prevent are actually going to occur by having to do all this again. So at this point, say we find something else later down the road. I mean, we could delay this case 3 months, 3 months, 3 months. It could go on, and every time you amend the complaint. And I don't think...
If the pharmacy were independent in terms of the claim against that the pharmacists weren't properly monitoring and giving advice to the physicians and so forth, would you have to pre-suit it?
Interestingly, pharmacists aren't included in the Medical Malpractice Act.
They're not healthcare providers?
They're not. But assuming it were independent and they were required to be...
Anesthesiologists instead of pharmacists?
Correct. Yeah, I believe it's... Because then they had no notice of the intent to initiate litigation. Here, the hospital...
There's two different things, though. There's the notice and the corroboration. The notice, there's no doubt the hospital had notice that as a result of this patient's ultimate condition, that there was a negligence claim being made against the hospital under a couple of different theories. That's the notice. But the corroboration aspect, there was no pre-litigation corroboration and no pre-amendment corroboration of this claim. And that's what the hospital keeps talking about. And that's, again, you go back and forth from the statute. Sometimes they talk about a claim, sometimes they talk about a case, sometimes it's talking about litigation. But it keeps saying you have to review and corroborate each claim.
Your Honor, I understand that your point. All I can say is I don't think the purpose of pre-suit was to require that every amendment to a complaint have to go through another pre-suit process. I mean, it's not pre-suit anymore. We're in litigation. We can flesh these things out in litigation. We still have to prove our case. It's not just as if we bring this in, we win. We still have to prove the pharmacists were negligent. We still have to meet the preponderance of the evidence standard. And, I think another point that this court made in Misra versus Trombley was that, the pre-suit statutes should be construed in a way that favors access to the courts. So if you construe it to require a plaintiff every time they discover new negligence against the hospital to have to go through a pre-suit process, that's not favoring access to the courts. That's hampering our access to the courts. So I think that, under that situation, that it's clear that we should not have to go through an entire pre-suit process each time we seek to amend the complaint. The defense also discussed the statutory changes, and I'd like to touch on that briefly, if I may. I don't see how those impact the situation here. Those dealt with qualifications of an expert. There's no change as to when the notice of intent had to be filed, when the affidavit had to be filed. All of that remained the same. So I don't understand how changing the qualification of an expert would change when you had to file a notice of intent.
We're trying to guard against frivolous claims requiring a specialist to review the medical records rather than in the case of the one nurse who said the doctors were negligent. You're more likely to get an accurate opinion if you require the same specialty and therefore weed out more frivolous claims. So I think that's the argument that they're making, and I think that's you could read that into the statute or see, okay, here's how they're making it more stringent. And in fact, I think one of our opinions talked about pre-2003 standards were less stringent than they are now.
That's true, Your Honor, and I don't think there's any allegation here or assertion that our expert who prepared the initial affidavit is unqualified. She was qualified to give that affidavit as it stood, so we initiated valid litigation.
As to the hospital pharmacy and whether they had a duty to develop a plan internally to make sure opioids were not being inappropriately prescribed, there's no proof that that expert has that expertise, that your nursing expertise has that expertise about pharmacy.
That is true, Your Honor. But again, the way I see the pre-suit process is serving the gatekeeping function of getting us, assuring that we're not just frivolously suing this hospital. And then once we've passed that pre-suit hurdle, there's nothing anywhere in the statutes or any cases that I'm aware of that requires us to pre-suit again. Again, I just think it could go ad infinitum. We could just continually be pre-suiting this case and drag it on for years. And I mean, every time you can prepare an affidavit, obviously you got to pay an expert. That's going to increase the expense. There's another 90-day pre-suit period every
And
time.
I agree, and from a policy provision, you may be 100% on the money, but when I look at the statute, it says it applies to all medical negligence claims. That's what's troubling me. That's why we have you folks here to help us sort this out.
Sure. And Your Honor, I think the statute that portion of the statute that refers to all medical negligence claims wasn't amended in 2003. That remained the same prior to 2003. So in that light, I think this court's decisions in Davis and Jackson are clearly still good law. And both of those cases support our position here today. In Davis, this court stated, basically, there's no requirement that the expert affidavit identify every instance of medical negligence committed by the hospital. As you noted, it's almost impossible to do that. We couldn't have done it. So the purpose is to prevent the filing of baseless litigation. That purpose has been met here. This litigation isn't baseless. As we went through discovery, we found new theories and new allegations of negligence that we sought to add to the complaint. But the litigation itself is not baseless. So I think we've met what Davis requires. And another important point from Davis was that under the hospital's position, the plaintiff could never amend a complaint on the basis of new evidence. As the rules of civil procedure state, we should be freely freely able to amend our complaint. So I think, again, from all these, looking at the situation as a whole, there's nothing that requires us to do another pre-suit process. And again, in Jackson, another case from this district, purpose of the pre-suit screening statute is to prevent the filing of medical negligence claims that are not legitimate, not to set forth every possible instance of medical negligence. Again, I think we've satisfied the requirements of those cases. Counsel briefly discussed Columbia, which is a fourth DCA case. And that case is really close on point because there the affidavit dealt with the negligence of an ER physician, but the lawsuit also included a claim of negligent credentialing. Now, those are two different, I guess you would say, standards of care, but they were still allowed to be brought in one lawsuit on the basis of the one affidavit. And I think this standard of care distinction that counsel discusses is somewhat dangerous because the way I see that playing out in the future is that the courts are going to have to determine in every medical negligence claim where you amend the complaint if there's a new standard of care. Because they're always going to argue, well, that's a new standard of care, you need a pre-suit again. And we're going to say, no, it's not a new standard of care, it's the same standard of care. So then the courts are going to get more and more cases to deal with and deciding, well, is this a standard of care? Is this a standard of care? And again, I know that's a policy argument, but I think it's just going to create more litigation on an issue that, this has been going on. We have been amending our complaints in this fashion since I've been practicing, and it's never been an issue. And, we don't amend to include frivolous litigation. We're not trying to sandbag the hospitals as they infer. I mean, that's an unfounded, fear.
Sounds like both sides are arguing sandbagging. The plaintiffs, the patient's counsel saying, well, the hospital can sit back and hide who was truly negligent until it's too late. And then all of a sudden, here it is, and we're out of luck.
It's
as
true.
opposed to being able to amend, and the hospital's claiming you guys are going to file pre-suit one thing and have 99 other claims. So.
It's true. And, I don't think either side is really doing that. I know during the pre-suit process that it's nearly impossible to get, sufficient discovery. You can't take depositions. You don't have any basis to compel documents. So, you kind of have, you get what you get, and you try to make your decision based upon that. So I just don't feel that, as this court's recognized, you can know all the allegations of negligence at that stage. And there are other consequences too. Think, for example, the arbitration provision. And this was a point made by the petitioner that, we've taken away their right to choose arbitration. So how does that play out if, say we do amend the complaint to add a new claim for medical negligence or a new allegation? Do they get to arbitrate just that claim? So now if they choose arbitration, do we arbitrate just that? Or do we now arbitrate the whole lawsuit? And I don't understand how that would work. And, there are damage implications as to whether or not you accept arbitration. Do those apply to just that one claim, or do they now apply to the whole lawsuit? I don't think the statute was constructed in a way to handle this type of situation where you have multiple pre-suit. It's called pre-suit for a reason, I think, because you do it before litigation commences, and then thereafter, you amend the complaint as you would in any other lawsuit. If this were an auto accident, we would amend the complaint, seek approval of the court, amend the complaint. I mean, the court still has to approve our amendment, even in this situation. So, again, I think that this pre-suit statutes just don't require us to do another pre-suit after we're already in valid litigation.
Counsel, just so I'm clear, did you say that the 766-203-1, the section that says pre-suit shall apply to all medical negligence claims and defenses, was that language the same as it was when we issued our opinion in Davis?
Your Honor, it's my understanding that the statutory changes in 2003 only dealt with changing, at that point it changed expert to same or similar specialty. It didn't change anything to do with the other language. And in 2013, they even removed similar specialty, so now it has to be just same specialty. But it's my understanding of it, and again, I guess I haven't read both the old version and the new version side by side, but based upon my research, what I understand the changes were just the qualifications of the experts, nothing to do with the timing of the notice or any of the language involving claims and that type of information, Your Honor.
Anything else?
Your Honor, if you have no further questions, I think I've
Any
made my
questions?
argument.
No, thank you.
Thank you so much. Counsel?
May it please the court. Judge Orfinger, you asked whether different affidavits on the initial complaint were required, and let me point you to the Mann case out of the Second District Court of Appeal, which is a 2015 case, and that is one where the hospital was alleged to be responsible for nursing negligence and alleged to be responsible for physician negligence. The Second District Court of Appeal found that the nursing negligence had not been corroborated, even though the physician negligence had been. The Second District Court of Appeal said that count one for nursing negligence had to be removed, but the hospital could still be on the hook for the vicarious liability for the physician negligence. That means that both affidavits had to be there at the same time with a notice of intent. Again, why would it change on an initial complaint versus an amended complaint?
Let me ask you the same question. 766-203-1, which talks about pre-suit shall apply to all medical negligence claims and defenses. Was that the same language that was in effect when we issued our Davis case in '95?
I believe it may have been, but what changes under sub 2 is the requirement to corroborate with those necessary expert affidavits, which I believe, Judge Edwards, you had mentioned as well. There is a footnote. I'd have to search through my case law, and I don't know that I have the time, but the footnote mentioning that these statutes have become more stringent for a purpose, because the Medical Malpractice Act works, but it only works if you comply with it. Your Honors, I have seen cases where notices of intent arrive, we go through the pre-suit process, and the plaintiffs have set aside their case because we have convinced them that it has no merit. I have seen the inverse as well. I've experienced it and I live it, where plaintiffs bring cases to us and we are convinced that it either requires an admission of liability and to send the case to arbitration, or that it requires settlement negotiations very early on. The point is to try to get to a resolution early, but it doesn't work if you don't comply. If you look at the Department of Administrative Hearings, I think it's close to 500 filed medical malpractice arbitrations now, and I would submit to you that there are thousands of other potential medical malpractice actions that never reach the courts because the parties comply. But when you don't, it prevents, it causes this process to evaporate, and it
And
increases
you're not aware of
litigation.
any other cases like you have here with a pendy-lighty amendment to add a new theory, a new claim such as that under this?
There is nothing that is directly on point with what we have here today precisely and under these statutes, but there are a great many cases that talk about how, where there has been a failure to pre-suit as to one, they are released. Bonatti v. Allen, Dr. Bonatti was released even though his partners were maintained in the lawsuit. Largy v. Gregorian, an ARNP, was released from the lawsuit because the affidavit only spoke to the physician negligence. The same principle
Counsel,
applies here.
I hate to cut you off, but you're
My
right
apologies,
over
Your
your
Honor.
time. Thank you so much.
Thank you for all your time.
Thank you.
Thank you both. Well-argued case.